Good afternoon. My name is Donald Lilly and I am a barrister. My practice area is in a field called Chancery Commercial, and I've been asked to talk about how that area of law relates to defending democracy. I recall when I told my lecturer at university that I wanted to become a Chancery Commercial barrister, he sighed and, with a fair degree of disappointment, said, "Oh, I see, you want to go into money." You see, all my fellow pupils were interested in careers in human rights or crime, especially international crime. My lecturer, and indeed my fellow pupils, perceived such areas of law as ones which did real good for the country, and indeed the world. By contrast, Chancery and commercial law was just about money. That is a common reaction to my field of practice, which concerns the management of companies, administration of trusts, and the winding up of insolvent companies and persons. The perception of this field of practice is often that it concerns petty fights between multinational companies or even billionaires, squabbling over sums that are of a size that most people simply cannot imagine. It is true. Recent cases I've been involved in have concerned, variously, a £6 billion shipping company, a $1.2 billion commodity trading group, and a $2 billion dispute between two Ukrainian billionaires, fighting over assets in the Crimea. All of this seems a far cry away from the principles of democracy in our country, never mind the average person's affairs. The impact of Chancery and commercial law on democracy is not as obvious as fields such as human rights, crime, and of course family law. But I'm here to make the case for the role that Chancery and commercial law have in our society, and indeed in our democracy. I will do so by way of a hypothetical case, which is in fact an amalgam of real cases I've been involved in. I'm sorry I cannot tell you about a specific case because a large number of my cases are either heard in private or at the very least concern highly sensitive, confidential commercial materials. Imagine a large industrial business based in the north of England. Let's call it Father and Daughters Limited. It employs thousands of workers and is a great success story of English industry. It is a leading company in the world, in its field worldwide, and most of what it produces is in fact exported to the US or China. That means that it is not only generating wealth from within the UK, but it is also ensuring that money is flowing in from other countries, which has a real benefit to the UK's balance of payments and trade account. This business was founded nearly 100 years ago, and it remains wholly owned by the same prominent British family. But here's where it gets controversial. The company that hires all of the workers and runs the business, Father and Daughters Limited, is a UK incorporated company. But despite generating over £150 million of income every year, it does not pay 1 penny of corporation tax. Not 1 penny. You might say this is an outrage, and I agree, on its face it is. But it is not illegal, and this is why. You see, whilst Father and Daughters Limited hires the staff and builds the products, does everything really, the brand name that is known worldwide, is in fact owned by a company incorporated in Panama. And every year that Panamanian company charges a license fee to the UK company in the amount precisely equal to the taxable profits of Fathers and Daughters Limited. That means that Fathers and Daughters Limited annual taxable profits are zero. So no tax is paid, as any percentage of tax on zero is, of course, zero. The Panamanian company then pays no corporation tax in that jurisdiction, so it sits on a massive amount of cash every year, which it can distribute to its shareholder. And indeed, its shareholder is a trust established in the Bahamas. And the beneficiaries of this trust are, you guessed it, the family that founded the UK business. Now, this structure means that prominent British family can and has amassed a vast fortune vaulted away in the Bahamian trust, free from tax. Now, if the trustee distributes money from that trust to the family, maybe to buy a property or even just to pay food or whatever it might be, then the person receiving that sum would personally have to pay income tax on it, and possibly other taxes like stamp tax. But that's a pretty privileged position, isn't it? I do not pay tax on what I spend in the UK. I pay tax on everything I make, everything I earn, irrespective of what I do with it. Your parents will likely be in the same position as me. Indeed, if you've ever had a part-time or holiday job, you probably will have experienced that as well. So, is it fair that this prominent British family has that tax advantage? Well, that's a political question. And indeed, it's a political question that the government asks itself every year when it prepares its budget. And almost every year, the tax rules change. The sort of structure I outlined above, which has been used not just by Fathers and Daughters Limited, but by a variety of UK household names, is largely now ineffective. But it was effective for many years. And new schemes are continually being developed like it for the wealthy British families and companies to reduce their tax bills. You might ask yourself again, why doesn't the UK just put an end to these sorts of shenanigans altogether? Why is it allowing the rich to get away with this? Well, there are two reasons for this. First, drafting legislation to think of every possible eventuality is extremely difficult, if not impossible. Sometimes these schemes emerge because it's hard to envisage all the different ways in which such schemes could be set up. As a consequence, politicians have to be reactive and amendments have to be made to shut loopholes as the schemes emerge and the loopholes become apparent. The courts also have a role in dealing with these types of schemes. The judiciary and the lawyers appearing before it are the individuals who must try and distill the intention behind tax laws which implement the budget. Courts are often asked to determine whether they should implement the spirit of the legislation or whether it should be enforced by the letter of the statute, by the very precise words used. In a recent Supreme Court case, the justices rejected a tax scheme established by a number of businesses, including UBS and Deutsche Bank, which was intended to allow employees to pay lower tax rates on the bonuses that they had been given by those banks. Although they appeared to have jumped through all the legislative hurdles, the Supreme Court instead interpreted the legislation in light of its purpose and shut down the scheme. However, sometimes the gap in the legislation is just too big, and it cannot be plugged. Indeed, these are big issues that can turn on very, very small details. I personally had a case that was litigated all the way to the Supreme Court, and it turned on just 2 words in a 958-page statute. As it happens, I lost that case, which meant that the government whom I represented lost a lot of money. Emergency legislation had to be passed through the Parliament to fix the mistake in the legislation, and incidentally, those 2 words became a whole new section of the Act spanning about 20 pages. The second reason tax schemes are allowed is that politicians also have to balance the risk of big successful corporations like the one I mentioned being not able to reduce their tax bill in this way and therefore leaving the UK altogether. The UK is not the only place in the world where widgets can be built. Perhaps Fathers and Daughters Limited could move across the Irish Sea to the Republic of Ireland. It has adopted openly for many years a low to no corporate tax regime to entice businesses to incorporate there. You might ask, well, who cares if Fathers and Daughters Limited leaves? It's not paying corporation tax, and it is true, it isn't paying corporation tax, but that doesn't mean that it is paying no tax at all. In fact, Fathers and Daughters Limited, despite its corporation tax structure, contributes a huge amount to the Treasury every year. You see, each one of its thousands of employees, including its managing director who made £13 million in just 1 year, pay income tax on their salaries, and that generates a huge amount of wealth for this country. And then those employees spend their money, largely, in the UK, on which tax is charged, whether it be VAT or stamp tax or otherwise. And of course, if those employees spend their money in the UK, they are supporting other businesses in the UK. Restaurants, clothing stores, car dealerships, you name it. So the contribution to our economy by the wealth generated by this one company is potentially substantial, even if it doesn't pay corporation tax. Wealth is not just generated for those hired by the company, but for the government itself and the residents in the UK generally. So sometimes the schemes are allowed because a political decision has been taken that is necessary to allow the schemes to remain in order to keep businesses like Father and Daughters Limited in the UK employing British citizens. Clearly, a question that needs to be answered to make that political judgment call is an economic one. It's whether the income generated by the company other than paying corporation tax is greater or less than the tax the government putatively should have received from the company but for the tax scheme. But then also politically, the government every year must decide how to balance these sorts of factors in publishing its budget. It is the biggest piece of government business every year. The budget is a hugely political process and is plainly influenced by which party or parties have decisive influence in the House of Commons. It is also something that hugely impacts the democratic process. In every election, perhaps save the last one dominated by Brexit, directly or indirectly, the economy is front and centre. Every party has to set out what it intends to do, and crucially, how they're going to fund it. If a party cannot explain how they will pay, for example, for vital services such as the NHS or school resources, their policies will be attacked as fanciful. So ensuring sufficient economic growth and tax revenue is a pivotal consideration for all parties. So wealth generation, coupled with its fair distribution, is also vital as it promotes good human rights. Time again in history, never mind the examples we have throughout the world today, we see economic hardships and substantial wealth discrepancy leading to civil unrest, persecution, and human rights abuses. Thus, political parties always have to deal with the tricky question of how to tax companies. Do you raise the tax and risk the companies leaving, or reduce the tax and risk companies not bearing their fair share of the burden of the country's expenses? Your views as to how to strike the appropriate balance is important, and you can influence this by knowing the party's positions on these vital issues and then voting for your party of choice. That, in its purest form, is democracy at work. But turning back to legal questions, turning back to Father and Daughters Limited, you might ask what the outcome was. Well, a question that arose from a case similar to that I was involved in was whether the trustee of the Bahamian Trust owed an obligation to become involved in the management of the UK company, involved in the management of Father and Daughters Limited. It's a difficult legal question, and indeed this question was litigated for 3 years. Ultimately, the answer was that a trustee does owe such an obligation, at least in some circumstances. Where the company is the main asset of a trust, the trustee must take steps to protect that asset and ensure that it is not mismanaged. That meant that by adopting the tax structure that it did, ultimately, the prominent British family lost control over its business. And that was something that the British family simply could not countenance. And in fact, it elected to largely dismantle the tax scheme voluntarily, rather than give up its control over its own business. This perhaps is an example of how indirectly and through small incremental changes in the law, driven by judicial decisions, big changes can happen. You see, if the government had legislated to ban the type of tax structure involved here, that imposition might have caused the family to reconsider moving the business elsewhere, and indeed might have caused other businesses to make that decision. Instead, the family voluntarily decided to dismantle the tax scheme because they considered the tax advantages did not outweigh the loss of control required by the law, by the Chancery law. So I ask you, do not dismiss Chancery or commercial law as something that has no real impact on our democracy. Our country's glorious democracy has been predicated for many centuries, not only on an atypically powerful judicial system and a strong root in the rule of law, but also its uncanny ability to generate wealth and progressively trying to make sure that wealth gets into the right people's hands. I'd like to think that my practice is a small cog in that great machine, which is continually refining that wealth distribution process. Now, normally I would open this up for questions, but sadly the COVID-19 pandemic has made that not possible. Indeed, that's why I'm not giving this talk to you in person, as I intended. So instead, I've been asked to speak about my experience in education in the UK. As you may have guessed from my accent, I was not raised in the UK. I was born and went to school in Toronto, Canada. But I came over to the UK for my university education, and I attended Wadham College in Oxford for my undergraduate degree, and then I stayed on to do a postgraduate law degree as well, called the BCL. Now, most of what I could say about the university experience and getting a placement, you've probably already been told, and it will be repeated to you ad nauseum over the next few years. So I do not intend to bore you with such things. But here are my personal points, specific to my experience that I think may be of assistance. First, I never intended to attend Oxford. I didn't think I had the grades, nor did I think I was smart enough. My sights were on other universities in England and in Canada, and I applied to Oxford simply because there was an extra space on the UCAS form, and to put it, I took what some might say was a punt. When I got there, I did reasonably well, and despite my fears that I'd be the least intelligent person at the university, I did manage to come away with a decent degree. So please take this. Do not sell yourself short. Secondly, my application record is not perfect. I was rejected from a few of the Canadian and other UK universities I applied to. I was rejected from all of my postgraduate degree applications other than Oxford. So take from this, do not avoid making an application to a top institution because of a fear of not getting in. You might not get in, but there's no shame in that. Very bright people are rejected from these institutions every year. That rejection does not mean that you are not intelligent, nor does it mean that you are not good enough to go there. And if you don't apply, you lose the opportunity of going altogether. Using a very Canadian expression from ice hockey, if you don't shoot the puck, you don't score. Thirdly, I personally have a very bright friend who ultimately had much better university results than me and got into a far more competitive chambers than I did. However, she was rejected from Oxford for her undergraduate degree. Not only does that make good the point I've just made, but it also shows that getting into Oxford or Cambridge or similarly excellent universities in the UK is not the be-all and end-all. Getting in does not guarantee success, nor does it mean that you will fail if you don't get in. There are lots of brilliant universities you can go to. Finally, I was greatly concerned that my strange accent and lack of English public school background would hamper me badly at university, especially one like Oxford. It did not. Indeed, personally, it did not. I attended a college, Wadham College, where the vast majority of students came from a state education background and from socioeconomic backgrounds far less privileged than my own. Moreover, no one cared about my accent. They only cared about what I had to say, which, to be fair, was not always that profound, but they didn't care about my accent. The key thing when going to a place like Oxford or Cambridge is to find the right college for you. Take the time. If you have the ability, visit open days of more than one college. Get a feel for what the college is like. And if you can't attend open days, try to speak to people who know about the colleges and have experiences with them, again to get a feel for what the colleges are all about. My university life did not centre around Oxford University, it centred around Wadham College. I hope this talk has been of interest to you, and I wish you all not only the very best success in your academic and future careers, but also the very best to you and your families during this COVID-19 pandemic. Thank you.